Hong Kong Stock Exchange Directors Training. Responsibilities of directors of companies listed on the main board of the Hong Kong Stock Exchange. 25. The Code on Share Buybacks. Hong Kong has a separate code on share buybacks. The Share Buyback Code distinguishes between 4 types of share buybacks. 1. On the market. This is the most unusual method and is normally carried out pursuant to the 10% general mandate normally granted at the annual general meeting. 2. Off-market. Off-market share buybacks must be approved by the Executive Director of the Corporate Finance Division of the SFC under Rule 2 of the Share Buyback Code. Approval is normally conditional on the approval of at least 3/4 of the votes cast by disinterested shareholders. 3. Exempt. Exempt share buybacks include an employee share buyback, a share buyback made in accordance with the terms attached to the shares, and a share buyback that is required by the law of the jurisdiction in which the offeror is incorporated or established. 4. By general offer. This usually takes the form of a tender offer of a certain percentage of all shareholders' holdings. A share buyback by general offer requires approval by at least 50% of shareholders in general meeting. A shareholder with a material interest in the share buyback will not be allowed to vote. If the buyback will result in privatization or delisting of the issuer, the approval of 75% of shareholders is required. On-market share buybacks. Main Board Rule 10.5 and 10.6 set out the relevant requirements in relation to on-market buybacks. An issuer whose primary listing is on the exchange may only purchase shares on the exchange in the following circumstances. The shares proposed to be purchased are fully paid up. An explanatory statement complying with the detailed contents requirements of the Main Board Rule 10.06(1)(b) is issued to the shareholders, and its shareholders have been given specific approval or a general mandate to make the buybacks by way of an ordinary resolution passed at a general meeting of the issuer duly convened. The explanatory statement must contain all information reasonably necessary to enable the shareholders to make an informed decision on whether to vote for or against the ordinary resolution to approve the share buyback. Such information includes, in summary, the following: total number and description of the shares to be repurchased and reasons for the buyback, the proposed source of funds for making the proposed buybacks, any directors or any associates of the directors who have an intention to sell shares to the issuer, or an appropriate negative statement, consequences arising under the Takeovers Code of which the directors are aware, if any. Details of any purchases by the issuer of shares made in the previous 6 months, whether on the exchange or not, whether or not any core connected persons of the issuer have notified the issuer that they have an intention to sell their shares to the issuer, and the highest and lowest prices at which the relevant shares have been traded on the exchange during each of the previous 12 months. Dealing restrictions for on-market buybacks. On-market buybacks are subject to the following dealing restrictions. No shares may be repurchased if the purchase price is higher by 5% or more than the average closing market price for the 5 preceding trading days. Shares cannot be repurchased for non-cash consideration. The issuer must not knowingly purchase its shares from a core connected person. The issuer must not repurchase its shares on the exchange at any time after inside information has come to its knowledge until the information is made public. In particular, buybacks are not allowed during the period of 1 month immediately preceding the earlier of 1. The date of the board meeting to approve the annual or interim financial results, and 2. The deadline for publishing any such results under the listing rules, ending on the date of the results announcement. No shares may be repurchased if the purchase will result in the number of listed shares held by the public falling below the prescribed minimum percentage. 2. Off-market share buybacks. Off-market buybacks must be approved by the SFC before a repurchasing company acquires any shares. Such approval will normally be conditional upon approval being given by at least 75% of votes cast on a poll by disinterested shareholders in attendance in person or by proxy at a general meeting of the issuer. Notice of the shareholders' meeting being accompanied by a circular containing 1. Details of the proposed offeree or offerees. 2. Terms and conditions of the agreement between the issuer and the proposed offeree or offerees. 3. Advice of an independent financial advisor and the recommendation of an independent committee of the board in relation to the off-market share buyback. A certified copy of the shareholders' resolution approving the share buyback being filed with the SFC within 3 days of the general meeting. And a copy of the agreement or agreements for the off-market share buybacks being available for inspection by the shareholders. 3. Buybacks by general offer. A share buyback by general offer must be approved by a majority of the votes cast by independent shareholders in attendance in person or by proxy at general meeting. The notice of meeting must be accompanied by the offeror document. If the share buyback will result in the delisting and privatization of the issuer, the directors of the offeror and any persons acting in concert will not be considered to be independent and therefore may not vote at the general meeting. And the share buyback must be approved by at least 75% of votes attaching to the shares owned by independent shareholders, cast in person or by proxy, and the number of votes cast against the resolution must not be more than 10% of the votes attaching to the shares owned by the independent shareholders. 4. Reporting requirements for repurchases. The issuer must submit for publication to the exchange through the Hong Kong Exchange-EPS a next day disclosure return no later than 30 minutes before the commencement of the morning trading session or at any earlier pre-opening session on the business day following the repurchase, showing the number of shares repurchased and the purchase price paid per share, or the lowest and highest prices paid. Listed issuers must also include in their annual report and accounts a monthly breakdown of the purchases of shares made during the financial year under review, showing the number of shares purchased each month, whether on the exchange or otherwise, the purchase price paid per share, or the lowest and highest prices paid, and the aggregate price paid. The director's report must refer to the purchases made during the year and the director's reasons for making such purchases. 5. Status of purchased shares. The listing of the repurchased shares will be automatically cancelled upon purchase, and the issuer must apply for listing of any further issues of that type of shares. The issuer must ensure that the documents of title of the repurchased shares are cancelled and destroyed as soon as reasonably practicable. 6. Restriction on new issue of shares following repurchase. An issue whose primary listing is on the exchange cannot issue or announce a proposed new issue of shares in the 30 days after its repurchase of shares, whether on the exchange or otherwise, without the exchange's prior approval. Exchange approval is not required for issues of securities pursuant to the exercise of warrants, share options, or similar instruments which were outstanding before the share repurchase. 7. Takeovers. Implications of share repurchases. The takeovers implications of share buybacks are set out in Rule 32 of the Takeovers Code. Under Rule 32.1 of the Takeovers Code, a share buyback is considered to be an acquisition by shareholders whose shares are not repurchased. This is because their percentage holding of shares increases even though the actual number of shares held does not. As a result, a shareholder or group of shareholders acting in concert could obtain control of the issuer and become obliged to make a mandatory general offer obligation under Rule 26. The executive will normally grant a whitewash waiver in the case of general offer obligations triggered by off-market share buybacks or share buybacks by general offer. Effectively, the Rule 32 whitewash mechanism applies only to a shareholder who is a director or person who is acting in concert with the director of the company. An unconnected shareholder would not normally be regarded as having triggered a mandatory bid obligation under Rule 26 if the increase in its shareholding is solely due to share buybacks by the company. Note 2 to Rule 32.